Okay, we'll get started here. So tonight we're just going to talk about various different issues about small business and some organizational type, more in-depth issues on family and small business situations. And I'm going to start off with what we call a shareholder agreement. So a shareholder agreement is a contract among the owners of a business. In a corporation, it would be a shareholder agreement. And in an LLC or a partnership, it would be an ownership agreement, either for the members of an LLC or a partnership, the partnership agreement. And the whole idea of a shareholder agreement is to put together issues into a contract that all of the owners of the business will sign, that will outline some of the issues that can come up during the operation of the business. What happens if somebody dies, what happens if somebody wants to sell out, and other types of issues. And if you don't have this kind of an agreement, then essentially it's going to be left up to potentially interpretation by a judge in court, or various different laws that may conflict with what the owners of the business actually want. So that's why it's a good idea to put together a shareholder agreement to outline the rules of what your ownership interest might be, and then also to make sure that you have in place ahead of time, in the event of a problem or a dispute, how those kind of things are going to be resolved. So when we talk about a shareholder agreement, it's basically a contract among the owners of the business that talk about restrictions primarily involving transfer of the ownership interest. So let me see if I can make that a little bigger. So one of the first and primary topics that's going to be discussed in a shareholder agreement will be a restriction on the transfer or sale of ownership outside of the owners or family members. So this is a really common type of a restriction that you'll find in small business. And the idea here is, without this type of a restriction, if you have somebody that maybe you have 3 owners, and one of them wants to sell or otherwise get out of the business, then they could just go out in the open market and sell it basically to whomever they want. And you may end up in business with someone you don't even know, or something of that nature. So one of the primary requirements or things that we want to address in a shareholder agreement is, first of all, an agreement that, there are handouts right there. An agreement that the ownership interest cannot be sold to other than another owner or a family member. If it's a family-run business, there may be restrictions built into the shareholder agreement that limit ownership interest to family members, and that needs to be also well defined. So for example, you might have a restriction on sale to siblings or lineal descendants, that is, children or grandchildren, as opposed to in-laws. That is a common restriction in family-run business, where you want to make sure that that ownership level over the generations passes through the lineal family, the blood, on down. And that is also true in the event if there is a divorce. In a divorce case, let's say you have one of the owners gets divorced, and a judge in the divorce case, the ownership interest in the business is going to be an asset of that divorce. It's called marital property. And so this is a real common situation in a small business or a family business, where you want to have in place a contract that everyone signs, and this may include a requirement that the owners of the business, as part of their estate plan, have a prenuptial agreement, which is an agreement that they enter into with their soon-to-be spouse, that makes it very clear that the ownership interest that they hold in the family business or the small business is considered individual property, and that in the event of a divorce, it will not be subject to division with the soon-to-be ex-spouse who is not a family member. And or you put in place a way that if there is a divorce, there is a way to fund payoff of the ex-spouse for the value of 1/2 of that interest. That could be done through either some sort of a savings plan ahead of time or an agreed upon payment plan that would be made, monthly payments for a period of years as part of the divorce decree. And this is also important because a judge in a divorce case, if we have this kind of a shareholder agreement with a restriction on transfer in the event of a divorce, typically judges are going to respect that and try to acknowledge that this is a family-run business, and because of the agreement, it would not be part of the division of assets. Or if it is going to be included in the division of assets, it is done through a different mechanism where maybe there's assets, more retirement account money perhaps goes to the soon-to-be ex-spouse, and the family member retains their ownership interest 100%, or some other equalization of asset distribution. So that's a really important part of a shareholder agreement, is restricting the transfer to other members outside of the family or the other owners. Now typically what we're going to see in that kind of a situation is the restriction would say if one of the owners of the business want to sell, the first thing they have to do is they have to offer and let the other owners know they want to sell, and then they have to offer them to buy out that person's ownership interest. And there's usually a period of time where it outlines how long that may occur, and in some cases we may even put into a shareholder agreement how the value, where do I have that on here, valuation of buyout, how the value will be established for that share that the person who wants to retire or do whatever. We may have a formula in there ahead of time on how that will be valued. That could be through, if you have a CPA that's been doing the accounting work for the company for years, the parties may agree ahead of time that they'll have that CPA perform a valuation based upon book value, which are the assets, accounts receivable, and other tangible and intangible assets, and provide a valuation that the parties will use. Or it could require an appraisal by a third-party appraisal company, or if the parties can agree themselves on how they're going to value it. In other words, some mechanism that's put in place ahead of time before this ever occurs, typically right at the beginning when you start the business is when you're going to do this, and they'll put in there how that valuation will take place. I have also seen shareholder agreements that already have a set value in there, and that value may change according to either a consumer price index, cost of living adjustment, or things like that. So that's a good idea to have that in there. If you don't have that kind of language in there, the valuation basically would be based upon appraisals, and each side would get their own appraisal done, and ultimately a judge might have to decide that if it ended up in litigation. And that's the whole idea of these shareholder agreements, is you want to try to avoid involving a court in the event one of these disputes arises, to have a way that that valuation may be done ahead of time. So back to the restriction, if I'm going to sell out, then I'm going to notify the other owners, give them an opportunity to first buy me out. It's kind of a form of right of first refusal. And that way, perhaps it'll say in the shareholder agreement, if I want to retire and sell my share, I have to give 90 days perhaps, or maybe 180 days, or even longer, depending on the case. I have to give notice to the company and the other owners that I intend to retire and I want to sell my shares. And then if we have a valuation, we would have that done at that time. And then once the valuation's done, then we determine how that buyout's going to occur. Now part of that may also be written into a shareholder agreement. So for example, I have one client, it's a family farm, and basically they've already written into their agreement that when somebody wants to sell out, they first have to offer to the others. They will have an appraisal done. The appraisal will be paid by the company from the funds of the company, and they agree ahead of time that that appraisal will be done, one and done. It's basically final. There's no fighting over it, which is I'm not sure if I'd agree to that because you never know what's going to happen, but they're basically, we're going to have an appraisal done by a third-party neutral appraiser, and they're going to give us that valuation, and that's what we're going to use. And then they have written into their shareholder agreement that the company will then purchase the partner that wants to sell out, and that'll be done over a 20-year period with quarterly payments, including interest at whatever the federal prime rate is, plus 2.5%. Right now, that would be about 7.5% APR. So basically, they're going to make payments, quarterly payments, over a 20-year period. So they've already written that into their agreement. That way, everybody knows ahead of time what's going to happen when you want to retire. You're going to try and sell out. That's assuming you don't want to transfer it on to your children. And that's another issue that you want to talk about in a shareholder agreement. Do you want to allow transition of the retiring owner's interest? Do you want them to be able to transfer that to their family after they die? Or do you want to have what amounts to what we call a forced buyout? So in other words, I have 3 children myself. So if I'm in business, family business, or a small business, doesn't have to be family. Let's say I have 3 partners, and I want to sell out, or maybe I don't. Do I have the ability to transfer my ownership interest onto my children? Now, that may not be something my partners want. They may not want to be in business with my kids, right? And vice versa. I may not want to be in business with their children. And so it's pretty common in a shareholder kind of an agreement that we'll put in place provisions that will allow a forced buyout in the event of death or retirement. And that way, the company has the ability to force the sale of the retiring partner or the deceased partner, and that way they don't end up in business with their children. Now that again would include valuation and a payment type plan or some other way to pay off the family for that partner's share. If it's a situation involving death, then oftentimes we will have life insurance that is built in to the shareholder agreement, and that life insurance is either paid by the company itself, and the life insurance proceeds will then be used to pay off the family of the deceased partner or the spouse of the deceased partner, whatever the case may be, and or some other mechanism to pre-fund how that buyout will occur. And that works very well. And again, it needs to be well thought out ahead of time. But the idea there is everybody knows in advance, when it's time for you to retire or if you pass away, you know how that's going to take place. It cuts down on disputes and it avoids potential problems going down the road. So that's what I mean when I talk about a right of first refusal. Right of first refusal is giving the other owners the first right to buy out that partner's share. We see right of first refusals also used in real estate. We'll talk about those in a different class when we get to real estate. But that's one of the issues that's pretty common, along with the restriction that the sale cannot occur outside of the other ownership interests or the family without everybody agreeing. Now, again, the way that usually works is you have to provide advance notice that you're going to sell out, and then everybody has the ability to buy it. But what if they don't want to buy out? What if they're willing to go ahead and have that person sell it to somebody else? Well, that may occur as well, but again, we have this process written out in the shareholder agreement that first gives everybody else the right to buy it, and then if they don't want to, usually we'll set a time period that they have to respond, maybe within 30 days of receiving the notice that the person wants to retire. And then they, after that, have 30 days to enter into a contract to buy them out or to provide them notice that they do want to buy. And if they don't give that notice, then basically they can sell their share to whoever is willing to buy it. The other type of situation where you might want to have a forced buyout is in the event that somebody becomes incapacitated. Maybe they develop dementia, Alzheimer's, or they're injured and they can no longer function, And you want that ability to essentially have the other owners of the business say, okay, you are no longer, based upon whatever your situation is, you no longer have capacity, you can no longer carry on, and therefore we're going to force a buyout. And unfortunately, it could be a little bit, I'm not sure if rude's the right thing, but you got somebody that's incapacitated, have dementia, and now you're forcing the family to sell. But unfortunately, that's kind of real world what you have to deal with. The other problem when it comes to incapacity is if a person becomes mentally incompetent, then oftentimes the family will apply to the court to have someone appointed as a guardian and conservator for the incapacitated person. And then at that point, the person that is appointed to be the guardian would have the authority to vote the incapacitated person's shares. And that may be the spouse, or it may be somebody else in the family. So essentially they acquire the ability to vote without even being an owner on behalf of the incapacitated person. So again, as part of that shareholder agreement, you would have details that set forth what happens if somebody becomes incapacitated and they can no longer carry out their duties, and forcing that buyout. Similarly, in a bankruptcy or insolvency situation, the way that bankruptcy works is when a person goes bankrupt, a case is filed with the bankruptcy court, and all of their assets then are subject to the jurisdiction of the bankruptcy court and the judge that's handling the bankruptcy. And that will usually be done through what's called a trustee, which is a third party that acts on behalf of the court and the creditors, the people that are owed the money. And essentially what can happen is, as part of the bankruptcy court proceeding, the owner who's filed bankruptcy, their ownership interest gets drawn into the bankruptcy court, and potentially though ownership interest can end up being sold to the creditors to pay off that person's debts. Now, the other owners don't want that, of course, because now you're in business basically with, a collection agency. And obviously you don't want that. They may end up becoming a 1/3 owner of the business through the bankruptcy mechanism. Now, I'm kind of simplifying that. It's not quite that simple. But again, this is where we would want in the shareholder agreement a paragraph that basically says that in the event that one of the owners files bankruptcy, the company will have the ability to force the sale of that person's share. Now, they'll have to pay the bankruptcy court the money, and basically that money would be paid into the court, and then that would be divvied up among the creditors to pay off the debts. But that way, the ownership interest is returned back to the company. You don't end up with a creditor, a collection agency, or somebody that is brought into the business kind of through the back door, through the bankruptcy. Another issue is if somebody's convicted of a crime. One of the partners, your owners, other owners, gets convicted of a crime. Perhaps it's driving under the influence case, and they run over somebody and they injure them. They're going to go to jail now for vehicular assault. They're also going to get sued, and you don't want their share to end up going to the person that they hurt. And so that would be a forced buyout in the event of a conviction of crime or other action that is detrimental to the company. That could be something other than a conviction. It could be maybe they were sued for a harassment type case or something like that, and you just flat out don't want them involved anymore because they're bad news, they're they're in the press or whatever the case may be. So you want to force them out due to either a conviction of a crime or other action that is detrimental to the business as a whole, reputation and everything else. So absent that, you may or may not have the ability to force the sale. It depends on the law of the state you're in, and it depends on what the situation is that occurred. but you may end up potentially in business with somebody that's sitting in prison, and you don't really want that. So that's where some of these other issues that we want to fold into and address in this kind of a shareholder agreement in the event of that type of a situation. Okay, another common issue that we talk about in a shareholder agreement is what happens if you end up in a dispute with the other owners. How are you going to resolve that dispute? Now, obviously one way is you go to court and everybody sues each other and everybody gets lawyers and it just gets nasty, right? Typically in that kind of a situation, nobody wins other than the lawyers, right? And so there are ways that you can plan ahead of time on how to resolve those disputes. So for example, we might have in a shareholder agreement, and this is especially acute in family business, where we may say in the event of a dispute among the owners of the business, before anyone can file any type of a court case, first they will have to go through mediation. Mediation is where you have a neutral third party who will come in and act as a facilitator, maybe hold meetings with the board of directors and the shareholders, the officers, the family members, put them in different rooms. You know, maybe you've got two factions of siblings that are fighting with each other. So we'll put one faction of siblings in one room. Maybe they'll have their lawyers with them, maybe they won't. We'll put the other faction in a different room and the mediator will go back and forth and try and hammer out an agreement on how they're going to resolve that dispute. And the shareholder agreement requires that, so that if somebody files a lawsuit without first going through mediation, you can take that shareholder agreement to the judge and basically you can tell the judge, look, we have this process in place already ahead of time. They didn't go through this process, they're in breach of the shareholder agreement, and therefore we want a court order requiring them to comply and then also pay our costs because they didn't follow through on that agreement. So it may be a mediation type of situation, or we may have a dispute resolution that requires arbitration. Arbitration is where you have an arbitrator who is a neutral party that acts like a judge that will basically review the case. You present evidence or your side of the story to the arbitrator, and then they will make a decision and tell you what the outcome is going to be, whether you like it or not, just like a judge would do. Really common. Or you might have a blend of having both a mediation and an arbitration. First you try mediation. If that doesn't work, you have an arbitrator make a decision, and you agree that that decision will be final and binding without any appeal. And the purpose for that is it keeps that dispute out of court. Also, especially with mediation, where you have the intermediary, that could be done in more of an, how do I say this, non-adversarial way. You know, if you go to court, it's kind of like combat in a way. You know, or you're fighting each other. It's an adversarial process. And that's not always really the best way to resolve disputes, because you're forced into this situation that you have to essentially say the other side's doing something wrong. Now, this may be your sibling, you know, or another family member, and your uncle or your grandparent. So you're forced into this situation where you're trying to prove that they're wrong, and that can actually make things worse rather than solve the problem. And that's one of the problems with our legal system as a whole, is it's adversarially based in terms of problem solving. And that's not really the best way, especially in family business, to resolve problems all the time. I have kind of a dumb saying, pot of coffee is worth 3 lawyers. And what I mean by that, you sit down with a pot of coffee, keep the lawyers out of it. I'm a lawyer, I know. Sit down with a pot of coffee and hammer it out. And that's worth 3 lawyers. And what I mean by 3 lawyers, you have a lawyer, I have a lawyer, and we have the judge, of course, is another lawyer. That's where the 3 lawyers come in. You can sit down and hammer it out over a pot of coffee. And that's usually the best way. Part of that is depending on family dynamics and ownership dynamics and personalities and all those kind of things. And that's where it's often better than trying to hammer it out yourself to bring in a neutral party to evaluate and do that kind of thing. Other types of dispute resolution methods may also, maybe you'll have a CPA who's been doing work for the company for years that will offer a solution. Or oftentimes it's a good idea to have a non-family member be part of the board of directors to act as a go-between or an intermediary, or a group of non-family members that, you know, they're not part of the family but they're on the board of directors, or maybe they're an officer, a president, or a chief operating officer, or some other officer position that's not a family member that can act as that sort of neutral third party on a daily type basis. So also as part of that, typically you're going to want a provision as part of the dispute resolution mechanism on how those costs are going to be paid, because mediation and arbitration and of course going to court, hugely expensive. And so we'll also want to typically include what's called an attorney fee provision, and that's a provision where it says that the prevailing party will be entitled to reimbursement of their attorney fees and costs, and or the company will pay for the costs of the mediator, the arbitrator. That way everybody's sharing the costs among all of the owners. So all of those kind of things. As part of that, we probably are also going to want, and this depends on how big the company is, but if you're multi-jurisdictional, in other words, you're doing business in more than one state, or even more than one country, you're going to want a provision in the shareholder agreement that talks about where the dispute will be held. If you're going to have arbitration, is it going to be held, you know, in Oregon, or are we going to do it in New York City, or where is that going to occur? So all of those kind of things, the shareholders that agree, you know, where the dispute itself will be resolved, what the jurisdiction and what law will apply. It's not always necessarily the law of the state where you're organized. If the dispute occurred in a different state where you have other facilities perhaps, the law of that state may apply even though you're an Oregon company. So all of those kind of issues are what we fold into that type of a shareholder agreement. Oftentimes shareholder agreement will have option to buy, proxies, special power of attorney, voting, and other control methods that we'll get in more to here in just a minute. And also what's called an anti-dissipation or anti-dissolution, where it's agreed that if there's going to be new ownership issue of stock, in other words, you're going to bring in new owners, the other owners will also have the right to purchase an equal number of shares, so they maintain their voting ability so that it doesn't get diluted by bringing in new owners. Or if you're going to bring in new owners, typically we'll have in a shareholder agreement situation where we want to bring in a new owner, and maybe that new owner is actually going to end up being a majority owner. They're going to input a lot of cash, and we're going to require, as part of the shareholder agreement, we're going to detail out, okay, if we're going to bring in new owners investment, is that going to require a unanimous vote of all of the other owners, a majority vote, 51%, or do we want to make that a super majority vote but not unanimous? So, for example, if we're going to bring in a new owner, maybe we require 67% of the current owners to agree to it. Otherwise, it's not going to occur. So those kind of issues, so that the other owners are not basically having their percentage voting rights essentially cut out from underneath of them by bringing in other owners into the company. The bottom one here, forced owner contributions in the event of cash flow or to adjust percentage of ownership. So what I talk about there is a situation where I had this case a few years back where you have a small business or family-run business, and maybe it's a rental house or an apartment complex. The one I had was a shopping mall. It was owned by a family. They had 5 siblings that owned it. They inherited it from their parents. Well, the problem was one of the siblings was kind of a deadbeat. Their agreement basically was that if they didn't have enough money coming in any particular month, that they would all contribute equally by putting cash to pay the property taxes. They had a mortgage, and of course insurance, maintenance and upkeep and all that kind of thing. And so, for the most part, they would have cash flow to be able to handle those needs. But they had a downturn in the economy. They had to do some roofing repairs and some repairs on the parking lot. It was all potholed, so they had to do a whole asphalt replacement. That was really expensive. And the problem was one of the partners, one of the siblings, wouldn't cough up the money. And so you've got these bills you got to cover. You got to pay the property taxes. You got to pay the mortgage. And so the other siblings had to basically put in more money. Well, the issue then is, okay, if our sibling is not reimbursing us for the money that we put out, how or can we adjust their ownership percentage down to reimburse them? Now, they didn't have an agreement in place that had any discussion of that, any part of that in the agreement. And so we ended up having to go to court on that one. But the judge ordered basically the deadbeat sibling. In fact, they ended up losing their whole share eventually. But so it's a good idea to have a paragraph that talks about forced owner contributions, and if the owner doesn't have the cash to do so, then the other owners can fund it, and then they'll get reimbursed either through the profits as they come through in the future. They'll have the first right to receive the profits of that one particular partner, or it may be a situation where you reduce down their ownership percentage until they've paid back what they owe, and then they get it back. There are different ways to handle that, but that's all something that oftentimes will be put into this kind of a shareholder agreement. So one of the things I tell people, small family-run business, try to think through, into the future about what could happen. Your family better than the lawyers do. You know your family, you know which siblings may or may not get along very well, or other family members that may have their own particular quirks to them or whatever. And how can you, ahead of time, try to put in place the paperwork now so that if these disputes arise, that you've got at least some ground rules in place on what you're going to do if that happens. This is also true for parents looking into the future. I have one family, they're farmers, and they knew their kids were going to duke it out as soon as they died. They knew that. And so we put into place, essentially they had a trust, and we put in, as soon as they died, an LLC would be formed. The farm would be put into the LLC, Limited Liability Company, and each sibling, there were 4 of them, going to get a 1/4 share. And it required in the LLC that if they're going to sell the farm, number one, they had to unanimously agree. The farm could not be sold unless they all agreed. So each of them basically had a veto. Part 2 was, if they're going to have major improvements done, then it had to be a supermajority vote. And then the third part was a use agreement. And in their case, they had a pond and kind of this cool family park area. They had a gazebo by the pond, a little dock, and so they had family reunions there and all kinds of stuff going back decades. Well, as part of that agreement, they had a usage agreement built in that talked about who can use the pond, when you can have, single family use, like if I just want my family there this weekend, or when it's going to be joint use, like for a family reunion, what type of activities would be prohibited, insurance, liability waivers, because they had jet skis, or not jet skis, well, that's what they used to be called, right, jet skis, personal watercraft. there's a lot of liability there. You know, you invite your friends over to a barbecue and somebody's out on the jet ski and they crash, you're going to get sued. Now, I don't want to get sued if my brother's having a party at the farm. So all of those kind of things, that was all built in to they thought this out very well. They also had houses on the farm, and one of the siblings, they gave exclusive use of that house because they'd already given the other siblings some other property. Now, they ended up in a dispute, but we had in place mechanisms ahead of time, you know, how to resolve that. So what I'm getting at here is it's very important to have these kind of documents in place. I will tell you, it's not always very comfortable, especially in a family situation, to talk about these things ahead of time. In fact, sometimes it can create problems where you didn't have any. But in the long run, it's better to have that agreement in place, at least the basics, if not all the particular details, so that it gives you a roadmap and people know, you know, what's going to happen in the event of that kind of a dispute. Okay, so let's move on to the next topic here. Whoops, what did I do? All right, so completely different topic. I'm going to kind of jump around a little bit. So now I want to talk about structuring small business, or this could be a large business as well, by using parent company, subsidiaries, and assumed business name, and kind of variations of that. So first of all, let's talk about an assumed business name. Talked about that a little bit already in this class. An assumed business name is when you are doing business in other than your legal name. This is sometimes referred to as a DBA, doing business as. Now, in the everyday world, usually this is referring to either a sole proprietorship or a general partnership that's doing business in a business name. But an assumed business name can also be filed by an entity, such as a corporation or an LLC. And there are creative ways to utilize assumed business names. I have another slide on this one. So there are creative ways or other ways to use assumed business names that may be beneficial to your company that really have nothing to do with the traditional role of using an assumed business name because you have to. So let me give you some ideas, and then we'll come back to the subsidiary. So first of all, one of the ways that you use an assumed business name, let me switch here for a minute. Escape. Okay, this is Secretary of State's website. So if you're going to register an assumed business name, you would do so on the Secretary of State's website, utilizing this form right here. As you can see here, assumed business name or DBA, doing business as. And essentially, assumed business name is required by law anytime you're doing business in other than your lawful name. That may include a corporation or any type of entity. And so the form you would fill out would be this form right here. Assumed business name. And essentially that name will be registered to the entity. So one of the uses of an assumed business name, I got to go back here for a minute, show you a different thing. Okay, this is the form to register a corporation with the Secretary of State. And I just want to show you this little area right here, because this is something a lot of people don't know about. So if you're a corporation, and this is also true of a limited liability company, an LLC, for a business corporation, the name must contain the word corporation, company, incorporated, limited, or an abbreviation of one of those words. So corporation or Inc., INC, company or CO, limited or LMT, or LTD, depending on how you abbreviate it. So that's great, okay? So I'm a corporation now. Okay, so I'm a corporation. I'm actually going to switch projectors here. Hold on just a moment. Okay, so I'm a corporation. Let's just call it ABC Incorporated. That's great. Well, as part of the requirement, you have to use that abbreviation in your legal name. That includes marketing materials, website, signs that you put out front of your business or on the side of your vehicle, you know, your company van, or if you're a trucking company, the side of your truck. That's great. The problem is you may not want to have Inc. or company or LLC, if it's an LLC. You may not want that in your marketing materials because it's just not really good marketing. So let me give you an example. Let's say I wanted to start a restaurant. Maybe it's going to be, I don't know, for some reason I have a Philadelphia cheesecake on mine. I don't know, I haven't eaten yet for dinner. So Philly cheesesteak. So I'm going to start Hasbrook's Hoagies, right? Little restaurants serve cheesesteaks and whatnot off my flat top. So I'm going to have my corporation, Hasbrook Hoagies Incorporated, Hasbrook Hoagies Inc. On my menu, Hasbrook Hoagies Inc. On my storefront or my little food cart. It's just kind of, ew, that's not really, you know, that doesn't really make you want to buy a sandwich from me, as opposed to just Hasbrook's Hoagies, which, you know, sounds a little bit better in terms of marketing for a restaurant. So I don't really want to have to use that Inc. in my name. So what I do, I start my corporation. That's going to be my parent, an S Corp, C Corp, or an LLC. Same thing, Hasbrook Hoagies LLC. I don't want to have to put the corporate or LLC on there. So what I'm going to do is I'm going to register and assume business name, Hasbrook Hoagies, without the Inc. My corporation name is Hasbrook's Hoagies, but now I'm just going to Hasbrook Hoagies without the Inc. and register it back to my corporation. Now I can use just that name Hasbrook Hoagies without having to have that incorporated on my marketing materials. And so that's a way that you can get around that requirement of having to put that corporate name in your marketing materials and elsewhere. Now it has to be registered back to the parent company that has the corporate name there. So you're still going to have to use that corporate in the legal name and, you know, your registrations and that kind of thing. So that's one alternative way that an assumed business name may be very beneficial, other than the traditional requirement for one. I mean, I could have Hasbrook Hoagies Incorporated and use Hasbrook Hoagies Inc. without having to register that name. It's just if I don't want to use the corporate name, the Inc., there we go. Now there's another way that this assumed business name can be used from both a marketing standpoint, but also from a branding and building a trademark, product line kind of thing. So now let's say I want to franchise Hasbrook Hoagies or whatever. And eventually my goal is to build up the business and I want to sell it. And then maybe I'll start another business and build it up and sell it. I'll flip the businesses. I have a client that does that. So the name Hasbrouck Hoagies, I'm eventually going to want to sell that name to whoever buys my business. That's a brand. And so when I register that assumed business name, number one, because it's now a registered name, I now have trademark and copyright protection. Before I ever register with the U.S. Patent and Trademark Office, as soon as I register that name, that provides the date and time and proof that I am the owner of that name. So there's a background thing happening there, because the way that trademark and copyright law works is whoever uses the name in the stream of commerce first has first rights to the name, and they can prohibit others from using the name. You have to be able to prove that you were the one that used the name first. And so this is a good way. I mean, you can register with the Patent and Trademark Office, but it's cheaper to file the assumed business name. You're still going to want to register it at some point. But nevertheless, I can register that name, Hasbrouck Hoagies, as an assumed business name. That gives me those trademark and copyright first in time proof, because it's registered with the state, right? So that's one component. The other thing, if I register that as an assumed business name, the way I'm going to do it is I'm going to have my corporate name be different than this trademark name. So my corporation, perhaps I'm just going to call it ABC Incorporated, with an assumed business name of Hasbrouck Hoagies. Now I can market that name, build up the brand, build up the name recognition, have a website, you know, all my menu and everything else, and build up the value, the goodwill, is what we call that, in that name, and the product lines and my different sandwiches and all of that. And so that way, when I go to sell the business in the future, I can sell that name. The buyer of the business will then have that name transferred from my corporation over to them as part of the sale. And they'll actually pay me for the rights to that name as part of the purchase price. Now, the reason I do it that way, I have a different corporate name than I do the assumed business name, because if I had the same name, I'd have to change my corporate name, because I can't sell that name without changing the corporation, because I'm going to want to keep my corporation. So this gives me the ability to both protect that name from a copyright trademark standpoint, but also create value in that name, which eventually can then be transferred to a future purchaser. And perhaps, you know, I may have Hasbrouck Hoagies, Hasbrouck's Hot Dogs, Hasbrouck's whatever, as different assumed business names that I could all then sell as part of a package without having to change my corporate name, parent name. That's a real common way that that's used as well. Now, another way to use an assumed business name is if you want to have different checking accounts. You don't want to open a new entity. So maybe, for example, I have apartment buildings. I want to have all the apartment buildings owned by my one parent corporation. But I have different apartment, and I want to structure it so that each apartment building has a separate checking account. Well, I registered an assumed business name for, you know, Ivy Court Apartments and 4th Street Apartments and, you know, Falling Down Rotten Apartments or whatever. And then I can have that assumed business name, I can take it down and get checks and have a checking account in those separate apartment names to compartmentalize the books for those apartments. Now there's another component to that involving LLCs, which we'll get to in a minute, but that's another way that you would use an assumed business name that's beyond the traditional method. There is another way that you'll use assumed business names, and that is if you're doing a franchise situation. So maybe, for example, I want to open a Taco Bell or a Subway sandwich or other kind of franchise type storefront. And this is pretty common, and especially in franchise restaurants, where I'll have my parent corporation and then I'll have different locations. So maybe I'll have Taco Bell, Monmouth, Oregon, Taco Bell of Corvallis, Taco Bell of Lincoln City, whatever. And I'll register those as assumed business names back to my parent corporation. That also might be a requirement of the franchise contract with the parent, the head, Subway, I can't remember the name of the parent company there, but Taco Bell, United Brands, or whatever it is. So the idea is they may require me to have an assumed business registration for that name to be able to lawfully use the name under the franchise agreement, which is called a licensing agreement. So I may have to do that as an assumed business name. One more. What if I am converting from a sole proprietorship or a general partnership? So I've used the name Hasbrook Hoagies as a sole proprietorship all these years, and I now want to convert to an LLC or a corporation because I'm a sole proprietor, I have unlimited liability, and I now realize, I need to be an LLC or a corporation. Problem is, I have all of my vehicles that have the name Hasbrook Hoagies without that Inc. or LLC on the side, or I have my, my yellow pages and my website, and all those materials don't have the Inc. on there. So this is kind of the reverse thing. Now I don't want to have to go get all new magnetic signs for my vehicle. I don't want to get new business cards made. I've already got all that because I've been doing business as a sole proprietorship for years. So again, what I'm going to do then is I'll start a corporation or an LLC in a different name, and then I will register the name, the assumed business name, out of my name as an individual, as a sole proprietor. I'll re-register it and transfer it to the corporate name. And that way I don't have to redo all my signs and everything else. That's actually a pretty common thing, where people start as sole proprietor and they convert to another entity. That way you don't have to redo all that. It saves a lot of money. So various different creative ways of using an assumed business name. Now, back to my slide. So LLCs can be used in a similar way to this assumed business name. But they add a whole nother layer of opportunities to protect yourself and to protect your asset and potential liability chain. So this is typically done through a subsidiary. When I say subsidiary, what I mean by that is a separately formed entity such as an LLC or a corporation that is owned by a parent company. So let's say I want to start a whole brand new restaurant. So I want to start maybe a different division within my current business that does a kind of a different type of business, or maybe an offshoot. Like for example, maybe I'm a real estate company and we, real estate realtors, brokers, salespeople, but maybe I want to start a property management division, which is going to handle rental for people and do all that. But I want that to be separated from the real estate sales side. Or maybe I have a farm that I do my normal farming, planting crops, and maybe I want to start a food processing division where we're going to process the materials that I have on my farm, my products, and turn them into, farm to table, maybe they're hazelnuts, so I'm going to have hazelnut candy, or whatever. Or I have a vineyard and I want to start producing wine. So I want to separate into a different product line or whatever. So what I do is I will establish a separate LLC in whatever name I want to use. That will be 100% owned by my parent company, my corporation. That may be an S Corp or a C Corp or even another LLC. And so let me talk about single member LLCs. Again, 100% owned by the parent as what we call a subsidiary. So a single member LLC, one of the cool things about it is you can use the same tax identification number, also known as employer identification number, EIN, TIN, same thing, as the parent company. Now, why is that important? I don't want to have to file a separate tax return for my LLC. I want to just file one tax return for my parent corporation. So by doing a single member LLC that is 100% owned by my parent company, I can use the same tax ID number when I open the checking account in the name of the new LLC. And all of the profit from that LLC or loss flows back to my parent corporation, and I file the corporate tax return and include the profit or loss on that one tax return. And so it's creating, again, a separation for both liability purposes, but also for accounting purposes. I keep have a separate checking account and all that, separate employees, and then all that money's flowing back, so I only have to do one tax return. So that's one of the really powerful uses of a single member LLC, is to use that, use it as a separation, and that way you can use that same tax ID number without having to file separate tax returns for each. Along that same line, another structure utilizing single member LLCs. So we have our parent company, let's just say it's an S corporation, S Corp Incorporated. So another use of LLCs, I'm just going to use an example. I have a client. Okay. So these are, let's say, apartment buildings. I have a client, she inherited 7 apartment buildings in Southern California from her parents. One of them's worth about 25 million, one's worth like 40 million. I mean, these are high dollar buildings, right? So she has a corporation in Nevada, no income tax, as the parent, and then she has separate LLCs in California, single member LLC for each separate apartment building. Now, why do you do that? Well, there's a couple reasons. Like we've talked about already, you have separate checking accounts, separate books, separate payroll in each different LLC. But these are high valued properties, so what we don't want is if somebody in this apartment building falls down and gets hurt and sues us, we don't want that to bleed over to the other apartment buildings. So we want to compartmentalize that liability. But again, we don't want to have to file separate tax returns and have a big convoluted bookkeeping mess. So that's where each apartment building then is going to be a separate LLC for the sole purpose of owning that one property. Now this could be apartment building, this could be rental houses, this could be aircraft or ships or other type of assets, other types of real estate, maybe farm ground, where you want to separate those out for both liability purposes and bookkeeping purposes into separate entities. And the best way to do that is for use of a single member LLC. And again, all of these are 100% owned back to the parent organization. So that provides this liability protection and compartmentalizes it. On top of that, there's some other reasons to do it that way. If and when she goes to sell the apartment building, she sells the whole thing as one chunk and then closes down the LLC or sells the LLC and it goes to the new owner. Then, and we'll get into 1031 exchanges later, but so she's going to sell that apartment building. The money's going to have to flow into the LLC. The apartment building gets sold, so she still has that LLC. Then she's going to buy maybe another apartment building as a rollover. It's called a 1031 tax-free exchange. That's when you sell one property. The money is held by the title company in a 1031 escrow account. And then when you buy another property, it's called a replacement property. You roll that money over to buy the next property. And that way you don't pay capital gain tax on that transfer. It's called deferred gain. And we'll talk more about that when we get to real estate, whenever we get to it, next week or the week after, whatever. But long story short, then when you buy the replacement property, you've already got that LLC in place, or maybe you start a new one. But in order to do a 1031 exchange, the money and the new property has to be in the same name. So that allows for, ahead of time, that compartmentalization both of liability, and then also, if you're going to buy and sell properties in the future, you keep them in that same LLC for tax-free exchange purposes. So the downside to this, and this depends on what state you're in, each of these LLCs has to be renewed every year. Well, in Oregon, that's $150. It's not that big a deal. In California, last I looked, it was $750 per LLC per year. Now, on a $20 million building, that's a drop in the bucket. But if it's a $300,000 rental house and you're having to pay $750 a year just to keep it open, that now is a little bit different story. That's more money. The other thing, when we talk about compartmentalizing liability, and whether or not it makes sense to have separate LLCs, you got to kind of look at, okay, it's going to cost me $750 per LLC. How much liability insurance will that filing fee pay for each year? Because if these properties are of not sufficient value to really warrant a separate LLC, use that money to bump up your insurance coverage. Because insurance is still going to be the first line of defense no matter what. So it may not, depending on the situation, it may not make economic sense to do this, as opposed to just having one LLC tied back and then buying more insurance. So you have to do a benefit analysis on that. But I just want you to be aware of, again, another way that we use LLCs to both compartmentalize liability, utilize different business names, and because they're single member, all of that money flows back to the parent, and then you file the one tax return at the parent level. And then if you sell it, you can splinter it off. Okay, so that's what I mean here at the bottom. Cost to maintain may not pencil out. That's what I'm referring to there. It may, the cost of doing that may not really be as beneficial. Okay. I'm forgetting something here. It'll come back to me. All right, let's move on and talk about, we've already talked about bylaws and operating rules, so let's go over and talk about proxies. Again, we're talking about documents that you may or may not use in a business environment, small business, family-run business. But I want you to be aware that they exist because they may make sense depending on the situation you have and the circumstances. So first of all, let's talk about what we mean by a proxy. A proxy is basically where there's an agreement that gives somebody else the ability to vote your shares of stock or your LLC membership interest in your place. So a proxy is somebody that is either doing something on your behalf for you, or maybe not doing it for your benefit, but they have the contractual right to vote your shares or vote your percentage ownership in a partnership or an LLC. Now, proxies are used in different ways. One way that proxies are used is if a person may not be able to attend a board meeting, if they're on the board of directors, or a shareholder meeting, and they may transfer their right to vote to someone else. Now that may be another owner of the business, it may be their spouse or significant other, it may be a child, it may be on an ongoing basis, so maybe I'm going to go on a trip or something and I'm going to be gone for a while, and so I want maybe my daughter to be able to vote my shares if there's a meeting that comes up. So in that sense, it's a form of a power of attorney where I'm giving special authority to vote my shares. And that may be critical if there's a meeting held and I'm gone, I can't attend the meeting, and I want to make sure that I get a vote on that particular issue. So a proxy can be used to transfer my voting authority to another person. Now, a proxy can also be used in a different way, and this is perhaps if you're going to bring in a new owner, or if I'm going to start transitioning to the next generation and I want to sell some of the ownership interests maybe to my child or whoever. So oftentimes that transfer may be on a payment arrangement. So like, for example, let's say we have a family business, the parent is going to transition out, and so they want to sell maybe a 15% interest in the company to their child. Their child can't afford it, so what the child's going to do is make payments towards that 15%, and the payments are going to come out of the profit that they would get as a 15% shareholder each year, along with whatever other money they have. But the thing is, the parent does not want to transfer their voting rights until they've fully paid off what they owe for that 15% interest. And so as part of the purchase of ownership interest in the company, the parent may reserve the right to vote those shares until everything's been paid off. And so that would be done through a proxy. So essentially, the child would then transfer the right to vote that 15% interest. It would be held by the parent, and then when they fully paid it off, they would revoke the proxy, and now the child can vote their 15%. Now during that time, even though they can't vote, they still get the right to retain the profits, but they transfer the right to vote for decision and management making purposes. So proxies can be used both in the situation to transfer their right to vote if you're going to be gone or can't attend a meeting, but it can also be used in another way, and that is reserving that right if you're going to sell to a child or something else. Or it could also be back to the bankruptcy or dissolution, divorce. You could say, okay, well, until we figure out ownership, the profits are still going to go to the bankrupt person or the spouse, but they don't get a vote. We're going to keep that voting right held by the family. So you'll have an income, right to the income, but not the right to vote. And that can also be done through a form of a proxy. So in the shareholder agreement I talked about earlier, that may be another provision of a shareholder agreement that limits or mandates, requires a proxy for a period of time when you bring in a new owner or the next generation of family, just to kind of get a feel for how things are going to go. And that way, if things are going well, you can get rid of the proxy. And if they're not going well, then you keep the proxy. That way, you know, they get the money, but they don't get the vote. This could also be used in a situation where somebody was incapacitated. That way they could transfer their voting rights to someone else. And that may be done ahead of time in the shareholder agreement, where the shareholders may basically say ahead of time, designate a person who will have their right to vote in the event they cannot do so. And that may be, there may be limits to that, because you may not want anybody with that authority. So it's just another creative way or another method that you can use to kind of control how that smaller family-run business is going to be transferred to the next generation, or when you bring in new owners. Also, this is a very common situation where I'm selling my business, for example, not to a family member, it's just somebody, you know, out of the blue, want to buy my business. We're not related in any way.